It's remarkable. This is a rapidly changing space. I was wondering if we'd, at this point in the conversation, break out some lessons learned in recent months. So Lisa, we'll start with you. What's the one thing over the last 6 months that really jumps out at you in terms of things that you have learned?
I think the key issue is have the right external experts at the table. You have to ask the right questions. If you're not asking the right questions, you're not going to get a sense of what the, and I'll frame this in terms of target and acquiring company, you're not going to get a sense of how the target company is operating in this space. You're not going to have an understanding of how compliant the target is with privacy laws globally, and of course most companies have data that is global, and there's a myriad of rules around data, both collection, use, and then also storage, data localization issues, data transfer issues. So we really have to get a very good sense of that. The target really would be wise to prepare in advance, get their house in order, as I said, and also ensure that the board is sufficiently well versed in this area.
Steve, how about you?
I agree with Lisa. It's having the right people at the table, and then it's really trying to understand the risk. And I tend to put the risk into 3 different buckets. One is, what is the legal risk? And that would include cost of lawsuits, cost of remediation, getting into legal compliance. The second risk is reputational. That's not going to be the same for all companies, but if you suffer a cybersecurity incident, what kind of effect is that going to have on the business because your reputation has suffered? And then the third is loss of key intellectual property. And so again, all the risk in each of those 3 buckets are going to differ for each company, but that's really the important task here for companies, is to understand the risk and make sure they're dealing with it.
Over the last 12 months, we've seen some companies that focus their attention on the risks before the closing and some companies that don't. The risks of not doing this kind of due diligence are that you inherit intellectual property that the acquired company actually didn't own. You inherit intellectual property that the acquired company didn't maintain properly. You inherit a security system in the acquired company that is riddled with holes and security vulnerabilities, and also privacy patches. Sometimes it's not just information that leaks, but it's a privacy practice that creates exposure when it comes to light after the closing. And so if you look at these issues before closing, you can price them and price them into the deal. If you don't look at them before the closing, you're stuck with them and you have to fix them on your own dime.
Alan, how about you? What's at the top of your list of lessons learned?
Without doubt, an increased appreciation of the magnitude of the challenge that's faced once there has been a major breach in trying to deal with it, trying to understand it. Remember, you got experts who've been in your system and have been hiding everything they've done as best they could. And just the challenge of getting to a clear understanding of how severe the situation is in a context where we live in an immediate world where the media expects you to speak right away with all the facts. And the fact of the matter is you do not have those facts. And you're likely to understate the crisis in a significant way. And Lisa and I, with your help, Eric, there was a situation in which I think a company made the decision, we will only disclose details once they have been confirmed by an external expert. And I think that was a very, very wise thing to do. It gave you a reason to pause until you really understood what you were talking about.
So Lisa, Alan brings up a really interesting point. We're talking about a series of massive challenges here, all kinds of scary stuff. That said, do we need new rules in order to meet the challenges we're talking about today? Does government need to act here?
I don't think we need new rules. I think we have enough rules. There certainly are. There's a panoply of rules in the data privacy space that need to be explored when you're entering into a transaction. And certainly systems have endless vulnerabilities that you can pinpoint. So I don't think we need new rules. I do think we need to apply the rules that we currently have in place.
Well, a question I would ask Lisa, I mean, she understands the diversity of the rules globally. I mean, do we need more consistency?
That's the $64,000 question. Yes, every business that we work with would like global harmonization. That's not going to happen in this space because privacy is culturally based, and so every country's laws reflect their individual cultures. It is very difficult, however, to operate globally where data does not respect country boundaries. It flows like water, and we have different rules that apply to the very same data set sitting in 12 or 52 different jurisdictions.
Over the longer term, do you think there will be convergence globally, or?
I do think there'll be convergence globally. We're seeing, for example, in Europe, by May of 2018, the General Data Protection Regulation will be effective, and that is intended specifically to harmonize data protection rules across the 28 member states. I think we will be seeing, there are many discussions now among data protection authorities globally. I think we will be seeing more consistency among the rules globally.
In New York, the Department of Financial Services has promulgated new cyber guidelines. Do you expect 5 years from now that there to be a patchwork like there is on data breach notification of 45 states having different DFS-style cyber regulations?
The short answer is yes. The longer answer is we have not seen, despite massive efforts, federal legislation in this area. Every year there's 1, 2, 3 pieces of legislation proposed, and nothing has passed to harmonize data breach notification. I absolutely think these new DFS rules will become more of the norm, but they will be a patchwork quilt. States will pass these laws, and I'll just note that the DFS rules require notification of an issue within 72 hours. That is directly reminiscent of what we're seeing in Europe. We are required in that space to file an annual certification with DFS as to compliance with the rules. So there are some very stringent requirements that I think will be picked up by other states.